Donoghue Stevenson is the landmark case that established the neighbourhood principle in law. Now here's the gist. On October 26, 1928, Mrs. Donoghue's friend bought her a ginger beer from Well Meadow Cafe in Paisley. She consumed about half of the bottle, which was made of dark opaque glass, when the remainder of the contents was poured into a tumbler. At this point, the decomposed remains of a snail floated out, causing her alleged shock and severe gastroenteritis. Mrs. Donoghue was not able to claim through breach of contract. She was not party to any contract, of course. Therefore, she issued proceedings against Stevenson, the manufacturer. The question for the House of Lords was if the manufacturer owed Mrs. Donoghue a duty of care in the absence of contractual relations. The law of negligence at the time was very narrow and was invoked only if there was some established contractual relationship. The House of Lords, deciding in favour of Mrs. Donoghue, with the leading judgment delivered by Lord Atkin in a 3-2 majority, with Buckmaster L. and Tomlin L. dissenting, held that, first, negligence is distinct and separate in thought. Second, there does not need to be a contractual relationship for a duty to be established. Third, manufacturers owe a duty to the consumers who they intend to use their products. According to Lord Atkin, the rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. Donoghue Stevenson established a fundamental principle in English law, the modern concept of negligence, specifically the duty of care. Prior to this case, the law of negligence was largely confined within the bonds of contractual relationships. The decision of this case effectively established thought as separate from contract law. The locus classicus of the neighbor test is found in another economic loss case called Caparo Industries against Dickman. I hope you enjoyed that little gist. Thank you.